Good evening, everyone. Welcome to the webinar on Basics of Arbitration in India, organized by Knowledge Teams. All of you are requested to turn off your microphones in order to avoid any disturbance during the session. Questions would be taken up after end of this session. The speaker for this evening would be Mr. Akash Gupta. Mr. Akash Gupta is working as an assistant lecturer at Jindal Global Law School. He teaches arbitration course, serves as the faculty coordinator of Moot Court Society and faculty board member of the ADIA Society. He propagates the use of ADIA and mooting advocacy through his workshops in different law schools, including NUAL, CNLU, TNLU, Alliance University, Savita School of Law. Also, he judges ADIA competition and moot competition frequently, including Jessup, Wiz, Stenson. I would now request Sir to kindly start this session.
Thank you so much, Megha. And thank you so much, everyone, for joining in this session. And let's begin this session. I'll share my screen. I hope you can see the slides now. Okay, so I have divided this session into 3 parts. The first one is where I'll talk about the basics of arbitration in India. And the second one is an online quiz, which will be playing through the use of your mobile phones. And the third one is the Q&A session, where you will be asking questions, any doubt you have with respect to the session. So let's begin with the first division of the session, that is arbitration and its basics. So let's start. So if you look at the screen, you see arbitration. So before we actually get into the legalities of what arbitration is, let's talk about what happens when you have a dispute. Let's say there are 2 companies, Company A and Company B. Company A is situated in Delhi, Company B is situated in Patna, Bihar. They enter into a sales contract of mobile phones. In this COVID-19 time, the seller was not able to deliver the goods within the delivery time provided within the contract. What happens? Usually, the parties go to the civil courts and start fighting over each other, and they have a dispute. However, during these times, and even in general times, in general circumstances, you have a lot of case workload with the judiciary. And also, if you move to the public fora, what happens? Does that affect the relationship which you have with the other party? So to solve all this issue in a closed environment, which means that whatever you decide, whatever you do is confidential. And this is one of the way to keep your relationships intact. So what you do, you go for a third party dispute resolution system, and you appoint a third party who is neutral, and they decide the dispute. So it's like you are selecting your own judges, which judge you want to go for. So, in terms of even judiciary, you see like some people who are really good in arbitration, some people who are really good in divorce cases, some people are really good in commercial matters. So in arbitration, what you do, you appoint the arbitrators. So you can choose your expert of the field, such as if you have an IT, if you have in smart contracts and somebody is an expert in that domain, you may choose that person as your arbitrator. And one of the important part of arbitration is that you do not have a system of appeals. So in case of litigation, when you have a dispute, you get a decision from the lower courts. You have a right to move to the higher court with an appeal. However, in arbitration, we do not have a system of appeals. However, we have a system of challenging the award. So challenging is a narrower perspective. However, appealing the award is very wide in powers. So that's about the final and binding nature of the arbitration, and therefore why the commercial parties decide to go for arbitration, because it's less time consuming, it's confidential, it helps you to maintain your relationship, and it helps you to not go into the public with the dispute. So these are the overview of arbitration. And one thing is very important with the recent amendments into the Arbitration Act is the fixed timelines. So for example, Section 42 Section 29A of the Indian Arbitration Act provides a time limit within which the arbitrators have to render the award. So there exists a timeline within which the arbitrators have to render an award, which means that there is nothing like an ongoing dispute for like 10 years. So you have a timeline, you need to follow the timeline. If you're not able to follow the timeline, what happens? You have to go to the court to get a permission for extension. Otherwise, the arbitrators lose their mandate. Mandate meaning their jurisdiction to decide the dispute. So in total, this is how an arbitration looks like. So this is the definition of arbitration: a third party deciding the dispute in between the two parties, and whatever happens is confidential. Okay, so that's about the arbitration part. Let's move to the next part. So before we get into the discussion of Indian Arbitration Act, we should know about two things actually. One is New York Convention and the other one is Uncitrall Model Law on International Commercial Arbitration. So New York Convention is one of the most successful treaty in the field of private international law. It is successful, most successful, because it has been signed by more than 160 countries. If I have to explain you what does this New York Convention is, in simple words, it provides a framework to recognize and enforce the foreign awards. To give you an example, let's say that the arbitration outcome is called an arbitration award. Okay, what the arbitrators decide and write, it's called an award. So the award is rendered in Singapore, which is another country, and one of the party is from India, and the parties want to enforce the award and get the money from the award in India. So you take the award from Singapore, you come to India. Because Singapore is also a signatory to this New York Convention, as well as India is the signatory, you have all the rights to enforce that award. So this is how this New York Convention works. If you are a signatory member, contracting state of this convention, you have a right to enforce that award in any of the contracting states. So that's one facet of New York Convention. Let's talk about the other one. Let's say that the state, let's say India is actually a New York Convention country. So one of the parties come to Indian courts to initiate a litigation proceeding, and the other party objects to it and states that you have an arbitration agreement. So the Indian courts have to refer the matter back to arbitration, because when you sign an arbitration agreement, there exists a positive obligation to undergo arbitration and a negative obligation that you will not go to litigate the dispute in the court. So that's the idea of New York Convention. And moving to the next part of Uncitrall Model Law. So Uncitrall is a United Nations subsidiary organ, and their aim was to design a framework, a model law for international commercial arbitration to reform and modernize the law in international commercial arbitration. So their idea was that in different countries, you have different arbitration law. But what happens if everybody has different standards within the arbitration law? Then even if you have an arbitration award in Singapore, and the moment you go to India, because of the different standards, what happened? Maybe the award will not be enforced, or the interpretation will be so different that it does not make sense for having an international commercial arbitration. So they designed this model law. Their aim was to work on the uniformity and certainty, that all the countries at least should have some consensus on the key aspects of arbitration. So that's the idea behind Uncitrall Model Law on International Commercial Arbitration. And India is a signatory to both of them, and India adopted both of them within the Indian Arbitration and Conciliation Act 1996. So that's the idea about the New York Convention and Uncitrall Model Law. Before we get into the concept of Indian arbitration, let's discuss about one of the things which is important as well, that is ad hoc arbitration and institutional arbitration. You must have heard about the recent New Delhi International Arbitration Centers getting set up by the government of India. There was a bill which was passed by the parliament. You must have also heard about the Mumbai Center for International Arbitration. So these international arbitration institutions are example of institutional arbitration. What is the difference in between institutional and ad hoc? So let's say if there are two parties and they decide to go for arbitration, they do not want to apply any of the arbitration rules. An arbitration rule is a set of guidelines which provides for each and every stage. How do you file your reference? How do you file your notice? How much time is required? How do you appoint your arbitrator? So it's a very clear. So there are a lot of process involved within the arbitration, and you have a right to sign up for an arbitration center. However, to let's talk about ad hoc arbitration in India. So ad hoc arbitration is more like a party driven concept where the parties decide to undergo the arbitration without involvement of an institute. So what happens? They do not have a law, they do not have an arbitration rule applied to it. So it's their own rule. So they may sit down and write their own rule, how they want to continue the proceedings. So it's up to the parties to decide the procedure for arbitration. And in case of ad hoc arbitration, there is no set of deadlines or timelines like within which you need to file the statement of claim, within which you need to nominate your arbitrator. However, all these things are there in the institutional arbitration. So institutional arbitration provides a very good support to the case and the parties to undergo arbitration, and they try to finish the whole proceedings within a stipulated period of time. So this is about institutional arbitration. One of the problem with the ad hoc arbitration is that you do not have a set of deadlines. So there may be a chance that you may exceed that timeline and you may delay the whole outcome of the arbitration. So in India, the prevalent one is ad hoc arbitration in the past. However, now we see a change, and there has been a shift in terms of opting for ad hoc. Now people are opting for institutional arbitration. So, and because also, if you may have heard about it, that the Mumbai Center for International Arbitration is having some cases. Also, New Delhi International Arbitration is going to be fully functional within some time. So these things show that now India is getting ready for the institutional arbitration. And the Indian companies before these institutions used to sign up to the SIAC, Singapore International Arbitration Center arbitrations, or the ICC Court of Arbitration. So that's the overall idea about the ad hoc versus institutional arbitration. So let's go to the next part. So now we talk about the Indian Arbitration and Conciliation Act. So the first thing which I'd like to focus on is arbitration agreement. So what is an arbitration agreement and why is it so necessary? That's the foremost question. So the origin for the power of arbitral tribunal, which decides the case, comes from the arbitration agreement itself. Because if you talk about the jurisdiction of the courts, there is nothing like parties coming together, signing an agreement, and then the court gets the jurisdiction. However, if you talk about the arbitration agreement or the arbitration per se, where is the jurisdiction coming from? The jurisdiction is coming from the arbitration agreement itself. So that's why it's very important that the arbitration agreement is valid. Otherwise, there may be a potential conflict with respect to the validity of the arbitration agreement. So Section 7 of the Act provides for the requirements that these are the things which are required to be in the arbitration agreement to make it a valid one. One of the important requirement is that the agreement to be in writing. So let's say if two parties enter into an arbitration agreement and they have a sale agreement within which you have an arbitration agreement. It's fairly simple that there exists an agreement to be in writing. But let's talk about another example, that the two companies has signed the sales agreement. However, they did not sign any arbitration agreement. However, when they were talking about the dispute in the email exchanges, they consented to each other that we want to go for arbitration and we will be resolving all our disputes through it. So what do you think, that agreement to be in writing is a very rigid concept, or do you think that it can be a flexible one in which it can be said that even if it's an email exchange or any kind of record which will help to showcase that there exists a communication, that will be enough? So the court answered that agreement to be in writing should be interpreted in a way to look into what was the intention to arbitrate. What was the intention of the parties? If there exists an intention to arbitrate and there was meeting of minds of the two parties, then it's a valid arbitration clause. And there is nothing like a prescribed form of arbitration agreement that only if it is written that both the parties hereby agree that any dispute arising out of the contract shall be resolved through arbitration, only then it will be a valid arbitration clause. There is nothing like that. The case laws has helped us to understand that we need to check upon the intention of the parties. So the test to know whether an arbitration agreement is valid or not is the intention to arbitrate. And one of the things which we should also focus is the finality of the decision. If there exists a clause which shows that there can be an appeal or there is a right to move to the courts after arbitration, do you think that is final and binding on the parties? If the answer is in negative, then there is no arbitration agreement, because in case of arbitration agreement, it is an arbitration and you do not have a right to go to the courts and get the decision from the court. So this is the framework of the arbitration agreement under section 7. And let's move to the next part. So section 10 and 11 of the Indian Arbitration Act talks about the composition of arbitral tribunal. So who is appointed as the arbitrator? The simple answer is that the parties themselves choose the arbitrators. However, there is a rule which provides that if you want to appoint an arbitrator, you may appoint 1, 3, 5, but you should not be appointing an even number of arbitrators. The reason is simple, that if 2 arbitrators are appointed, what if there is a situation that the arbitrators themselves are divided while writing the award? So one party states that party A should be winning the case and the other party says that party B should be winning the case. To safeguard this situation, the Act provides that the arbitrators should not be appointed in even numbers. So what happened? There was a case in which there was an even number of arbitrators. So after losing the case, the losing party went to the courts and challenged the validity of the arbitration agreement. They stated that because it was in clear violation of the Act, even number of arbitrators were appointed, this is in violation of the Act. Therefore, this arbitration agreement is itself invalid. However, the court answered that this even number of appointment does not affect the validity of the arbitration agreement, because at the end there was an intention of the commercial parties to resolve the dispute through the process of arbitration. But it is advisable that the parties should ideally have odd number of arbitrators to remove all these potential conflicts at a later point of time. And now let's talk about how parties appoint the arbitrator. So usually you have 3 arbitrators. So in case of 3 arbitrators, this is how it works. So party A appoints an arbitrator, party B appoints an arbitrator, and both the appointed arbitrator decide who will be appointed as the presiding arbitrator. So this is how it works in case of three arbitrators, but in case of a sole arbitrator, the parties have to agree on one of the arbitrator to be appointed as a sole arbitrator. So that's the part about the composition of arbitral tribunal. And let's talk about the challenge of the appointment of arbitrator. Just to give you an insight, let's say that there are two companies. One is a builder and the other one is a subcontractor. Both have a construction contract providing that the sole arbitrator will be appointed and the sole arbitrator will be the director of the builder's company. So in this case, what do you think? Do you think that there exists a potential conflict because one of the party's own director will be sitting as an arbitrator and deciding the dispute in between his own company and another company? So in these cases, is it fair enough? So what is the test provided within the act? The test provided is justifiable doubts as to his independence and impartiality. So in this case, if the arbitrator is a director of one of the companies involved in the dispute, he gets a salary from the same company. And if he is appointed as an arbitrator, there exists high likelihood that he'll not be independent and he will be partial. So in these cases, it is clear that just because you have a right to appoint the arbitrator, to choose an arbitrator, it does not mean that you may choose an arbitrator who is biased and who will not decide the case with fairness. So you need to keep in mind that somebody who has been appointed in the panel, he should be independent, or she should be independent and impartial. So that's about the part on challenge of the appointment of arbitrator. And let's talk about the competence provided within section 16 of the act. So just to give you an example, let's say if the contract validity is itself in question because one of the parties argue that the contract is itself invalid. So a contract is also having a clause of arbitration agreement within the same contract. So what happens if you challenge the validity of the contract? Who gets the power to decide that the contract is valid or invalid? So the simple answer is that the arbitral tribunal gets to decide whether the arbitral tribunal is whether the contract is valid or not. But what happens, let's take this example a bit further. The arbitral tribunal decides the case because of the reason that they get the power to make a decision on the validity because they have been given the power by the parties by an express agreement, that is the arbitration agreement. So let's take this example a bit further, and the same contract which is argued that it is invalid, it has a clause, that is arbitration clause. What happens if the contract is itself invalid? So the argument made was the arbitration agreement shall also be invalid because it is contained within the contract itself. However, the law is that even if the contract is invalid, it does not automatically affect the validity of the arbitration agreement. And this doctrine is called Doctrine of Separability. So it states that if there is a question or validity of the contract, the arbitration agreement is separable from the contract. So that's the Doctrine of Separability, and it is provided within section 16 that just because the contract is null and void, it does not per se affect the validity of the arbitration agreement. There needs to be two separate investigations for the validity of the contract as well as the validity of the arbitration agreement. And the principle of competence provides that any jurisdictional objection to the arbitral tribunal or with respect to the validity of the arbitration agreement shall be heard and decided by the arbitral tribunal. So that's the idea about the competence and doctrine of separability. So while undergoing this arbitration proceedings, there are certain ground rules which the arbitral tribunal has to take care of. So one of the important things which the arbitral tribunal has to take care while undergoing an arbitration proceeding is the equal treatment of the parties. So equal treatment is not a mathematical equality. So let's say if the two parties, one of the party get a chance to argue for 3 hours and the other party gets 3.5 hours to argue at the final stage, it does not mean that the arbitral tribunal has treated the parties unequally. However, if one of the party gets 4 hours to argue and the other party just gets 1 hour to argue or even no argument at the final stage, what happens? Then it's a case for unequal treatment. So in these cases, it becomes a problem and you have a right to object to this unequal treatment. And the other facet of this part is the full opportunity to present its case. So imagine that in one of the case, expert report is very essential. And the expert report was provided to one of the party. However, the other party did not get the report even to look at it and to get a chance to cross-examine it. So in that case, the party which did not get the expert report to cross-examine the other party or cross-examine the expert itself who has drafted the report may argue that he, she, or the party did not get a full opportunity to present its case. So as an arbitral tribunal, it is important to keep in mind that equal treatment of the parties are very essential. Because if the equal treatment is not provided, it is one of the ground to challenge the award on this basis. And the legal force of the award will not be there if it is successfully challenged. So that's the idea about Section 18, equal treatment of parties. Here comes the important part, that is Section 20, place of arbitration. Place of arbitration is often called as seat. So let's talk about what a seat is. A seat is more like a route to the arbitration. So let's say if somebody says that the seat of arbitration is in India, what does it mean? It means that the arbitration proceedings have to be in accordance with the law of the Arbitration Act of the seat. So if the seat is India, then the Indian Arbitration Act will apply to the arbitration proceeding. So that's one facet. The other one is that if there has been an award and there has been the award has been rendered by the arbitral tribunal in India. It's seated in India. If you want to challenge the award, where do you go to challenge the award? You go to the seat courts to challenge the award. Like this, you have several stages where the court may interfere in a way to assist the arbitral tribunal. So the seats interference, how they interfere with the arbitration is very important. So if you look at the other jurisdictions like Singapore or France, how they interfere with the arbitration is something which you need to focus on before you choose them as a seat. So if you choose an arbitration friendly jurisdiction like France, there exists high likelihood that the arbitration seated in France will have minimum court intervention from the judiciary. So that's something you need to take care of. And also with respect to the procedural issues, like whether costs can be awarded or interest can be awarded, or interim measures, or in case of evidence taking, the seat courts may help you to go ahead with the arbitration proceeding. And if you look at different seats, so different seat has different standard of setting aside, how they interfere with the arbitration. So in US, there exists a ground which provides that manifest disregard of law is one of the provision based on which you can challenge the award. In UK, an error of law is another ground. Likewise, in India, you have a set of provisions provided under Section 34 based on which you can set aside the award. So, but this is more about the legalities of seat. But let's talk about from a different perspective about the seat. Let's say if you're a company from India and the other company is from Malaysia. So which seat is better for you? So you need to choose a seat which is neutral. So instead of choosing India as seat or Malaysia as seat, it's better to choose a country which is not India and Malaysia. So if you choose a seat such as Stockholm Chamber of Commerce as the arbitration institution. So Stockholm is in Europe. So it's very far and the geographical location matters. So instead of choosing a European country, it's better to choose a South Asian country like Singapore or Philippines, Vietnam, or any other country in this region. So that's about the geographical location. And with respect to the neutrality, also you need to keep in mind that the neutral country like Singapore, there exists high likelihood that that neutral country is also a pro-arbitration country, meaning that the level of court intervention is very low. So if in case you have an arbitration, it will go very smooth and there will be no interference from the court side. So that's about the seat of arbitration. And in one of the famous judgments from the Indian Supreme Court, that is Balco in 2012, the Indian Supreme Court discussed about the seat at length, like whether an arbitration award can be set aside it only at the seat or it can be set aside it even outside the seat. So the Supreme Court answered that only the seat courts will have a right to set aside the award, which is in line with the Uncitrall Model Law on International Commercial Arbitration, 1985. Before this 2012 case, by the Indian courts were actually setting aside the foreign seated arbitration as well. But now the law is clear on this, that only the seat courts will get a right to set aside the award, has the power to set aside the award, and not the other courts. So that's about the place of arbitration. And let's move to the next part. As we discussed in the last part, that there exist certain grounds based on which the parties may go for setting aside of the award. So there are different grounds provided within Section 34. Let's discuss this one by one. So the first one is that the party was incapable. So that's one of the ground. Second one is that arbitration agreement is itself invalid. So if the arbitration agreement is invalid, then the arbitral tribunal loses their own jurisdiction. The third one is that the party was not provided due notice of the appointment or any arbitral proceedings to present his or her case. And fourth one is excess of mandate. So let's say that the two companies, while signing the arbitration agreement, provided that A, B, C, D will be within the jurisdiction of this arbitration. However, while deciding the case, the arbitrators went ahead of this four corners and they decided a dispute which is not covered within the arbitration agreement. What happens? So even in that case, you may apply for setting aside and the court will consider it. So that's about the excess of mandate. The fifth one is the composition of the arbitral tribunal. was not in accordance with the agreement of the parties. So let's say the parties agreed that the arbitrator should have this much of minimum qualification. However, the arbitrator appointed was not fulfilling the agreement of the parties. Even in that case, you may challenge the award. The sixth one is, what if a subject matter was not capable of settlement by arbitration? So let's talk about an example where a divorce case is ongoing and the two parties sign an arbitration agreement. They have an arbitration award as well. The arbitrator has decided that there should be a divorce or there should be no divorce, and this is a sum of money which party A should give to party B. But afterwards, the losing party go to the court within section 34 and argue that this subject matter is not suitable for settlement by arbitration. So divorce is something which has been provided in different cases by the Indian Supreme Court, is not suitable for settlement through arbitration. So that's the ground. And the next part is public policy. So if anything provided within an award is against public policy, against the fundamental policy of Indian law, what happens? In that case, the award can be set aside as well. And the last ground is patent illegality. So this is more like, when we discussed about the UK error of law. So this patent illegality is pretty much similar to that. And it provides that if the arbitrators have decided something which is so irrational that nobody can reach to that conclusion, in those cases, you exercise this exceptional power and set aside the award. That's the patent illegality. So this patent illegality was not a ground before the 2015 amendment. It came after 2015 amendment. And now the parties have one of the ground, patent illegality, within section 34. However, when you decide a case within this patent illegality ground, the court should not get into the merits of the case. It's just that the court should look into whether the decision making of the arbitrators, is it so irrational that nobody could have came up with that conclusion. Only in those cases, the court may set aside the award using this ground of patent illegality. So that's the framework of setting aside. Let's move to the next part. That is section 36, that is enforcement of the award. So if the setting aside timeline, it provides that within 3 months, you need to, after the 3 months, you may enforce the award. But what if that the arbitration award has been rendered and the timeline provided to set aside the award is over? So what happened? In those cases, you may enforce the award, and the award shall be enforced actually in accordance with CPC 1908, and it will be deemed to be a decree of the court. But the question is, what if a party applies for setting aside within the 3 months timeline, but the court has not decided upon that issue? So after the 3 months time, what happens? Can you enforce the award, or are you required to wait till the setting aside proceeding is over? So this was actually issued in the case of Hindustan Construction case. So the court answered in negative and said and held that there is nothing like an automatic stay on the award. If you want to stay the enforcement of the award, you need to file a separate application when you apply under section 34. If you just apply under section 34, there is nothing like the impugned award is stayed. If you want to stay the award execution or the enforcement, you need to file a separate application for the stay on that impugned award. So this was the issue before the amendments. However, now after the recent amendment and the recent judgments, it is clear that there is no automatic stay. So after the expiry of the 3 months time limit, then the party may move for enforcement. So that's the overall idea of the arbitration in India. And now we'll be having a quiz, and please focus that how you actually play. I'll tell you now. So the questions will be on your screen. So I'll be sharing my screen. You'll get the questions and you get like options. And the options, you have to opt in to the options by entering with another, with an app, or if you have the desktop, you open the other window, and then you have to sign up. I'll give you a code and you have to go to that website and you just get into that game, and then we'll play. So you'll see the questions on screen. However, you need to answer through your mobile phones or the laptops. You need to pick your answers. So let's go to the quiz. Okay, so you need to go to Kahoot. So if you see the screen, you need to go to this Kahoot, kahoot.it, this one. You need to go to this website, or if you have the app, kahoot.it, which is KAHOOT.it. So you need to go to this kahoot.it and enter the game pin, which is right here. Okay, so we wait for some time so that everyone joins the game, and then we'll start. So if you just join now, what you need to do is go to this website called kahoot.it, and you need to enter this game pin to enter the quiz. Okay, I see people joining in, so let's wait for another 3 minutes and we start after that. Okay, so I see new people joining in, so let's wait for another 2 minutes and then we'll be starting. Okay, guys, so this is last 2 minutes. If you are not still into this quiz, please go to this kahoots.it, which is there on this screen, this part, and you need to enter the game pin, which is right below that. And we start at sharp 4:45. You have last 60 seconds to.
I started. 1 minute left, sir.
Okay, so now we are starting. The question is on the screen now. You'll see the options on your mobile phone or your laptops. You need to enter it. Okay, so this quiz is not to actually do an evaluation about your understanding. It's just to act as a checkpoint so that I know like what concepts I have been able to convey. So in an arbitration, the question is which of the following is not there? So an arbitration is always confidential because that's how you actually maintain the relationship in between the parties. And the decision of that arbitrator, that is the arbitral award, is final and binding. And of course, the party has an autonomy. It's just that the strict rules of procedures are not there like you have in the litigation, that is the court side. And I see that only some people have opted for the answer. So what you need to do to opt in for the answer, you see, like you have used the device to log into the game with your PIN. You need to answer on that same screen. You need to opt one of them. The question will be on another screen and the answer will be right there on your mobile phones or your laptop. You need to opt in. You need to click on that icon. Okay, so let's go to the next question. Okay, so in our discussion, we discussed that the New York Convention is for the recognition and enforcement of a foreign award. So it does not deal with the domestic awards. It's just the foreign awards, because for the domestic award, it's the mandate of that country. to regulate how they want to regulate it. So it's only the foreign awards which has been covered, sorry, within the New York Convention, okay, and not the domestic awards. So the answer is foreign awards. Okay, so I see even now only around 40 people has opted for the answer. You need to opt in through the device you have logged into this game. So you just see the options with the colors and the symbols. You just touch that, click that, and then your answers will be here. So let's go to the next question. Okay, so we see a change in the scoreboard. The third question is on your screen. Okay, so this is pretty much clear that India has adopted the model law on international commercial arbitration. So let's go to the next question. Fourth question is on your screen. Okay, so we discussed about this, that the institutional arbitration has a set of rules and they guide you throughout the arbitration process. So yes, the answer is true and you got it right. So let's go to the next question. The next question is on your screen. Okay, now we need to discuss this because we see the majority has opted for the true one. So the oral arbitration agreements are not valid. You need to focus on section 7. It provides that the agreements to be in writing. However, it's not that a rigid concept, but you need to showcase on some sort of medium in a written form, maybe an email, a WhatsApp, or an arbitration agreement or a contract. But oral arbitration agreements are not acceptable as a valid arbitration agreement because it is very tough to prove that the oral arbitration, the oral agreements, it is very tough to prove that. And also the oral agreements are not enforceable within the Indian law. So the oral arbitration agreements are not valid arbitration agreement. Okay. So if you have any questions, please feel free to type in, and then after the quiz session, we'll open the Q&A. And if you have questions, we'll come back to you. Okay, so let's go to the next question. Okay, so you got it right that the parties should have odd number of arbitrators to avoid future issues. So even if you have even number of arbitrators, it will not be invalid, but it will create a lot of problem at a later point of time. So ideally the parties should have odd number of arbitrators, and you got it right. So let's go to the next part. The question is on your screen. Yes, it's the arbitral tribunal, because the arbitral tribunal is the one who has the competence to decide the jurisdiction and the validity of the arbitration agreement. So the correct answer is arbitral tribunal. Some people have opted for parties. So the parties never decide things. Like, of course, parties guide them, parties appoint them, parties say in the beginning that this is the rule which you need to follow. However, the parties not decides anything. It's the arbitrators who decide it. So the people who sit on the panel to decide the dispute is called arbitral tribunal. So the right answer is arbitral tribunal. So let's go to the next question. Where the arbitral award shall be enforced. So we discussed about this, that the seat courts will hear the challenge about the arbitral award and not any other courts, because that was something which finally the Supreme Court decided in the case of Balco in 2012. So that's about this question, and let's go to the next one. The question is on your screen. So if the arbitral award is so irrational that no reasonable person would arrive at the same conclusion, is it a ground for setting aside? Yes, it is a ground for setting aside. That is patent illegality, which we discussed in section 34. So the correct answer is yes. Let's go to the next part. We see a change in the scoreboard, and here comes your last question. So the question was, if the set aside application is pending, is there automatic stay on the impugned award? The answer is no, because we discussed this in the case of Hindustan Construction Company, that the court held that there is nothing like an automatic stay on the impugned award. You need to file a separate application to stay the award. There is nothing like an automatic stay. So that's about this question, and let's check out the scoreboard. Okay, so the names are anonymized. If you want, if this is you, please write your name on the chat box so that we know who was the actual winners of this. So congrats to all of you. And you'll see on your screen, you'll see a feedback form. You can just opt in. You just need to type like thrice. You just need to click 3 things and the feedback will be done. It's super easy. And we see the scoreboard. So I think it's anonymized name. So if you are giving octopus, glider, crane, giving piranha and wombat, then please write on the chat box that who are you, so that I know you. And congrats to all of you for participating in this quiz. However, the idea behind this quiz was to know that whether you have passed the checkpoints or not. So that's why I was discussing about the questions after I see your answers. So now, if I think we have some minutes to discuss about, to talk about your questions, if you have any. I'm not sure if you have typed your questions. So yeah, over to you, Megha. Yeah.
Some questions on WhatsApp.
Yes.
So one of the question is,
Yes.
what are the new dimensions that are coming up in the field of arbitration in today's world? And what will be the situation after lockdown? Will the scope in this field remain as it is?
I think if we look at the present scenario, I think there are a lot of disputes upcoming. So I think that there will be more disputes, so there will be more arbitrations and more online dispute resolutions. So in a way, it will be a boom for the online dispute resolution, and there are a lot of people talking about it. So if we talk about the Agami Foundation or Sama or Resolve 360, they are upcoming with platforms which you can use from your home itself, and you resolve the disputes through arbitration or online mediation. So I think that even during this COVID-19, there is a boom for EADR actually. So yeah.
The next question is, What is the meaning of seat and venue in arbitration?
Okay, so just to answer it with an example so that you get the clarity. So let's talk about an example. There are two parties, an Indian party and a Singaporean party. They have a contract and they decide that they want to go for an arbitration. The arbitration hearing will be in Hong Kong, and they chose Malaysia as the seat. So the difference in between seat and venue is all a geographical thing. So where the hearings will happen, like where in the room they'll go sit together and they decide the dispute. The geographical location of the hearing is called venue. That will be Hong Kong. But the law applicable to the arbitration proceeding will be the law of Malaysia. So the difference in between seat and venue can be anywhere in the world. You can meet in Miami beaches because you want to have a good holiday there. But the seat is something which is very important because the court interference, the setting aside, interim measures, taking of evidence plays an important role with respect to the seat. So if you choose any venue, it's just that you need to go there to decide the dispute physically. However, in terms of COVID-19, let's say you have decided that Miami will be the venue. Now you cannot travel. It doesn't matter. You can use the online platform as the venue. But however, the seat is very important. So that's about the difference in between seat and venue.
Does the law of limitation applies to arbitral proceedings?
So there are contrary opinions on this part. However, we have a specific provision within the Indian Arbitration Act, which provides that the timeline provided under the Limitation Act applies. However, the court judgments have different opinions on it. Some judgments say that as Arbitration Act is a special act, so whatever timeline provided within the Arbitration Act is fine. However, the other set of judgments say that the condonation provided under the Limitation Act also applies. However, the better view is that even under the Limitation Act, it is provided that if a special law has provided a timeline, that will override the Limitation Act. So if you ask me personally, it's better to apply the timelines provided within the Arbitration Act rather than applying the limitations provided under the timelines provided under the Limitation Act.
The next question is, what remedies are available where one party denies that the tribunal has jurisdiction to determine the dispute?
So if the other party is not ready to undergo an arbitration, what you do, you go to the courts and you say that I have an arbitration agreement. Here is the contract. Here is the arbitration agreement. So the other party will be getting a notification from the court and he'll be asked to undergo the arbitration. There is no way out. If you prove that there exists a prima facie validity of the arbitration agreement, the other party has to submit to arbitration because you have agreed to it. So there exists a positive obligation of getting into that arbitration and resolving the disputes.
The other part of the same question is, does the jurisdiction recognize the concept of competence?
Oh, can you repeat your question?
It's the same part of the previous question. So does the jurisdiction recognize the concept of competence?
Yes, of course, it recognizes the concept of competence because, so the idea is the moment you sign up an arbitration agreement, you give the power to the arbitral tribunal to decide upon the jurisdiction. That itself is called competence. So they may decide any objection even against them. So even if you challenge one of the arbitrator, they themselves can decide that because of the competence.
The next question is, are international commercial arbitration and international arbitration both the same or different?
Okay, so international commercial arbitration is a different sphere. So let's talk about arbitration. There are different kinds of arbitration. One is domestic arbitration, which means that two Indian parties are involved. Let's say a party from Delhi, another party from Lucknow. International commercial arbitration means where there exists an element of commerce, which means trade. So let's say if the Indian party is selling its rice, like in case of Shilal Mahal, they're selling its rice to a European country, a European consumer. In that case, it's an international commercial arbitration. The other kind of arbitration is investment arbitration. So just to give you an example, you must have heard about Nissan Motors. So Nissan Motors have invested heavily in Tamil Nadu, and they were of the opinion that they'll get a lot of tax rebates. However, at a later point of time, they didn't get. So they started an investment arbitration case against India. So investment arbitration case is the investor gets a protection. So the investor can sue the government of the other country where they have invested. So Nissan filed a case against the Indian government, against India in itself. So that's investment arbitration. And if you talk about international arbitration, so it can be international investment arbitration, it can be international commercial arbitration, it can be an international arbitration in terms of the border dispute. So you had a Kutch arbitration in between India and Pakistan. That's also an international arbitration, but that's not a commercial arbitration because it was related to border dispute. So that's how, there are different perspectives to it.
The next question is, what is the jurisdiction of online arbitration? Seat of arbitration in case of cyber arbitration.
Okay, so technically there is no clear-cut answer to this because right now you have e-platforms giving you a chance to go for online dispute resolution. So there is no clear-cut answer because unless until the courts decide something on this, however, it should be valid. There should be no issue to it because now in terms of COVID-19, you're not expected to go like everything should be physical. However, there has at least to my knowledge, I didn't see a case in India actually that whether the court said whether online arbitration is valid or not. However, according to the international commercial arbitration practice, the trend is in favor of the online arbitration and the Indian courts should also take up this view, but I'm not sure if they differ from this.
The next question is, how do one establish oneself as an arbitrator? How do we start at both national and international level?
Okay, so it's a very good question, but there exists a caveat which I have to tell you at the beginning itself that according to the recent amendment to the Indian Arbitration Act, it provides that you need at least 10 years of experience to be an arbitrator. So maybe your dream of becoming an arbitrator according to the Indian laws is a very distant dream. That's the reality. However, there are different ways to pursue arbitration. So as I have talked about several e-platforms. So the first step towards being an arbitrator is when you start learning about it. So there are different courses in the legal field to pursue, and the first step towards becoming an expert in arbitration is also learning about the tribunal secretary. How do they work? So I'm not sure if you can be an arbitrator within 10 years of experience according to the Indian law, but there are different people I see who are interested. They become the tribunal secretary. In short, if I say what is a tribunal secretary, it's more like, somebody who assists the arbitrators during the course of the arbitration proceedings. So you get to know about it. And of course, you have several moods on arbitration. You have different papers, you have webinars, you have a lot of courses. So these are the things which will help you to actually learn arbitration. And I'll highly suggest to intern with any arbitration center or you think you can go there and learn from them. That's also a good way to go forward.
The next question is,
Yes.
can 2019 amendment bring about such changes so as to reduce the huge numbers of Indian international arbitration in SLIC?
Okay, so I'll answer this question with a scenario actually. So if you look at the civil hospitals anywhere in India, you see a board which provides that who gets a free treatment. And it provides that people who are pensioners or who come from a background or they have the BPL card, they get the benefit of free treatment. So the analogy is the same applies to arbitration. Just because you have the very good law or a bad law does not mean that it will change the whole scenario of arbitration. There are some things in the recent amendments which are good. For example, inclusion of confidentiality within section 42A, which is a good thing, that whatever happens within an arbitration setup, it's confidential. One of the things which has been criticized a lot is 10 years experience for being an arbitrator. What if I tell all of you that in Stockholm, in Sweden actually, who becomes an arbitrator? Anyone who can sign a contract or who can be a party to the contract. This is the qualification required to be an arbitrator. So in India, you need 10 years of experience in the legal field. Only then you become an arbitrator. So like to answer about the 2019 amendments, it's a good amendment in some parts. In some parts, we need to improve a lot. But however, it's a good step towards moving to, towards the dream of our Prime Minister to convert India into a hub for international arbitration. So even the Niti Aayog report talks about it. So the vision is good, but still we have a long way to go and achieve that dream of becoming an hub. I think you are on mute, Megha.
Sorry. The next question is, what is the future of arbitration after COVID-19? Do you think online dispute resolution methods will help people living in India?
I think yes, because like if you talk about arbitration in especially in the Indian jurisdiction, arbitration is more about, it is also about traveling, going, like all of the parties come from different places, their lawyers come from different places, and you meet at a central point, which incurs a lot of cost. So using these online platforms, any platform, including Zoom, or let's say any of the Indian ODR platforms, any platform will help you to reduce the cost and expenses regarding this. And I have seen a lot of people on LinkedIn, the top mediators from US, who have said that if you want to take my services as a mediator, if you accept the online mediation, I'm going to reduce my fee from 100% to 75%. So if this change, or if this wind comes to India, it will actually result into reducing the cost, which is actually directly proportional to more cases or more accessibility of ADR in India. I think that will help.
Can you talk about the concept of due process paranoia?
Okay, so with respect to this due process, it depends on each case to case basis, because the problem with due process paranoia is the arbitral tribunal is not a public forum. So the arbitral tribunal has one of the objection from a party with respect to the due process is not followed. What happens in that scenario? The arbitral tribunal, let's say if the arbitrators are Indian arbitrators, they have a different perspective to it. If they're from a different jurisdiction like US or UK, they have a different perspective to it. And usually the Indian arbitrations are not having any publication of the awards, even the redacted version removing the names of the parties. So actually you don't know what is happening in the arbitration. It's only when it goes to the court, setting aside or any other interference, only then you get to know about it. So to answer this question is pretty tough unless until you know like what has been the process of decision making by the arbitrators. So yeah.
What are the kinds of arbitration agreement in India?
I like, can you explain? Okay, like kinds of arbitration agreements, it's mostly like the parties agree within the contract itself that the parties agree to go for arbitration. But in some cases, in minority of the cases, they actually, after the dispute actually arise, they decide that they will go for arbitration because it makes not commercial sense to end up into fighting in a court. So basically, like usually the commercial parties, I read a report which provides, I think it's PwC, which provides that the Indian parties, 90% of the Indian companies who have a turnover of more than 500 crores or something, which was there in the survey, go for an arbitration agreement just to get a safeguard that even if a dispute arises in the future, they will not be going to the public forum, that is the court, and deciding it there.
I think we're done with the questions, the most relevant ones. Also, there are various questions regarding if you could share your PPT.
Yes, I will be sharing it. Can I share it to you after this, and you'll be sharing it to everyone? Yeah, I'll be sharing it to all of you. Don't worry about it. Yes.
So thank you, sir. On behalf of Knowledge Teas, I would like to thank you for conducting such an insightful webinar.
Thank you. Thank you to you for inviting me.
Thank you, sir.
Thank you.